4510. And Cindine, if you would put that into the little chat box, which is in your lower left-hand corner, that'd be terrific.
I certainly will.
So that text box in the lower left-hand corner is something that we're going to be using today to collect questions. And so if you have any questions or any problems, you can write your questions in that box. So what you do is where it says type here to send a message, put your cursor in there, click on it, type what you want to send, and then hit enter, and your text will then appear, and everybody will be able to see it. Okay, so why don't we go ahead and try that? If everybody could just say where you're calling from. If you signed in from your email, your name is going to appear right there. Okay, so just go ahead, and if people will just say where you're calling in from. And if there's more than one person with you today, if you could let us know how many people are at your station, that would be great. So if everybody can just let us know, you can see that we have people from all over the country signing in now. Great. Just, if people can just go ahead and type in where you're calling from. And Cindine, do you see that person who's having trouble with the speaker?
No, I don't. I'm having cut and paste issues here, but I will go back.
Okay. It's Lightstetta.
Okay.
Okay, great.
All
right, Cindine just got in the phone number there. All right, so sorry that took a little bit.
Yeah, buggy. It's buggy.
Yeah. Some of you already heard me say the webinar system did a major tech upgrade this weekend, and I think you've all gone through tech upgrades and you know how smoothly they tend to go. So we are still working out some bugs with them, so I apologize in advance. As I think you already know, all the participants are muted, and that's why you need to use that chat feature for the question. And so if you have substantive questions, you can put them in there, and what we'll do is we'll collect the questions during the webinar. And time allowing at the end, we'll pose as many as we can to the presenters. And Cindine will be collecting those, and she'll be posing the questions to Melissa and Scott at the end of this. And if any technical problems come up, you can private chat me. My name is Sue Osthoff. You can go over to that private chat tab, which is next to the public chat tab. And you can just click on that, and you can send me those questions. Or you can send them to Cindine, and her name is Cindine Pazel. So it's Sue Osthoff or Cindine Pazel. And if you happen to be on the audio portion only today, that you're not signed in through iLink, you can also email me with any questions. And my email is sueo, S-U-E-O, @ncdbw.org. And either I or one of my coworkers will get back to you. Again, it's sueo@ncdbw.org. We are recording this webinar today, and we're trying to get these up on our website as quickly as possible. And they're generally getting up there in a couple days. So it's about a week it should be up there. So you can go back if you want to listen to it again. And the recording actually has both the audio, and it also will pull up the PowerPoint again. At the end of this webinar, I'll send an email to you, and it will contain confirmation of your attendance, and it will also include a link to our website where the recordings will be, and also a little brief survey. And we really appreciate it if you take really 2 minutes to fill it out. The more feedback we can get, the better we can get these webinars to be in the future. We also have a couple of short questions that we would like you to answer, and it's really helpful to us and to the presenters to know who's here. So what I'm going to do now is actually, let's go down to the next slide here. We're going to ask you a couple of questions, and what we want you to do is actually, those of you who are signed into iLink, please answer them literally on the screen. Like take your cursor up and answer it by clicking on the little dots that appear on the screen. And don't answer it in the chat box. unless you're answering other. So first, let's go to the questions, and I'll show you what I'm talking about here. So we want to know who you are, how you describe your profession. If you're a community-based advocate, go ahead and click that little dot there, please. If you're a clinician, social worker, therapist, please click that little dot there. If you're other, not one of those things listed above, click that little dot there, please. And then go over to other and put in your answer, please. And you'll see there's 4 questions, so we'll give you a minute or 2 to answer them. First, how do you describe your profession? Then we're wanting to know if you've ever participated as an expert witness in a case involving domestic violence, sexual assault, or other types of trauma. And we said participated because we know sometimes people get hired or get asked to work on a case and do work on a case but do not end up testifying. And so that's why we use the term participating. And we do mean that beyond simply being asked. It's that you worked on a case, that you were involved in a case. So yes, you have. No, you haven't. And then we also are sort of interested in finding out, no, I haven't, but I'm really interested in doing so. And then it's very important to us for our funding source to know, and for us to know if you're an OVW grantee, and if you are, if you can go down to the last one and tell us which grant program you are with. Okay, so I'm going to share the results of this now. So you can see that, are you seeing the percentage come up, Cindine, Melissa, Scott?
Yes.
Yes.
Okay, great. So this gives you an idea that we have mostly community-based advocates on this call, but you also see who else is there. Okay? So we'll move on. Thank you very much. Again, if you're having any troubles, Cindine, could you put the iLink number back up?
Yep.
And we will be collecting questions during the webinar. And then we'll ask them, time allowing, at the very end of the webinar. So feel free to put your questions down in the chat box there. For those of you who just joined, I'm Sue Ostoff with the National Clearinghouse for the Defense of Battered Women, and I do want to extend a warm welcome to all of you. This is the 4th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. And if you missed any of the first 3 webinars in this series, the recordings that I mentioned, they also pull up the copies of the PowerPoints once you start listening to it. They're posted on our website, and that is ncdbw.org. And Cindine, could you put that into the chat, please? And once you get to the website, just go to resources, and you'll see the recordings. And basically, you go back in and sign into iLink. It was just like when you signed up for this webinar, and then you can go and get the recording. There is one other webinar at this point scheduled in this series, and it's on the prosecution's use of experts. And that will be presented by Chris Malios from Equitas, the Prosecutors Resource Center on Violence Against Women. And that will be on June 20th from 3 o'clock to 4:30 Eastern. And once we get going, I'll put some additional information in the chat box about that. So please watch your email for announcements about that. I also really want to thank the Office on Violence Against Women for the support of what I think is a very exciting project about expert witnesses. It's really been great to have this opportunity to do some work and thinking with others around the country about these important issues. And I also want to extend my thanks to our colleagues at BWJ, the Better Women's Justice Project in Minneapolis, for the continued and really, truly excellent help and support with our webinars. Just a quick heads up, there are a lot of materials actually posted on your Google Docs site, and there is a copy of the PowerPoint there actually in 2 formats. It's a PDF version, so you'll be able to print it out. You can't print out the PowerPoint from here, but you will have access to it. That link is, Cindine just posted it, and it's also in the email that you received this morning. You should not need a Gmail account or a password or anything to get in there. Again, we'll put your questions down in the chat box. Okay, so finally, let's get going. As you know, today's webinar is titled Preparing for Your First Case as a Domestic Violence Expert Witness. And our presenters today are Melissa Skaya, who is here, and Scott Miller, who is there, are just really two amazing and wonderful people. And they both have a really huge amount of experience doing anti-domestic violence work and doing that work in many different arenas and in many different ways. And they've both done direct service, they've created and run programs, they've developed resources, including curricula, they've been involved in policy development, they get asked to participate in all sorts of think tanks and roundtable discussions, and they conduct training programs, and lots of them, all over this country as well as internationally. And we're really lucky to have them today. And they do all of that work, and they live in northern Minnesota, and Scott just said it's 45 degrees there today. They really have long winters, and they still get all that work done. I'm very impressed. Seriously, they both have enormous amounts of experience, including testifying as experts, which is why we've asked them to present today. And in an effort to save time, I know that print is really tiny, and I apologize. Their full bios are up on the Google Docs. I really do encourage you to go and look at them because they really do have such vast and varied experiences. And I just think that it's worth really knowing who's talking today. But I really want to turn this over to them. So I'll just say very briefly that Scott Miller has been working with the Domestic Abuse Intervention Project, which is in Duluth, since 2000. And currently he coordinates their coordinated community response to domestic violence under a demonstration project funded by the Office on Violence Against Women called the Blueprint for Safety, which I think many of you have heard of before. He's been working in the women's movement since 1985, and in recent years has started testifying as an expert in criminal and civil trials, during which he explains how the tactics of abusers and the associated risks generated by battering are linked to the counterintuitive behaviors of victims. And he'll certainly be talking more about that today. And, I was thinking, how can I possibly introduce Melissa Skaya briefly? But in an effort to get this over to them, I am going to try to do so. And again, encourage you to read their bios, just so you can see the huge range of experience. Melissa Skaya is here, and she is the Executive Director of Advocates for Family Peace, and that's a 6th program agency that provides services to families experiencing domestic violence and child abuse. It's how do you say it?
Itasca.
Itasca in northern St. Louis counties in Minnesota. About an hour and a half from Duluth?
Right.
And I actually got to know Melissa when she was facilitating a group of victims of battering who ended up getting arrested. And she started doing training programs with her coworker, Laura Connolly, because they were learning so much about facilitating groups for women who ended up being arrested, survivors of battering who ended up being arrested. And they were just learning a lot about the women themselves, and they were really generous to share that information. And then Melissa and Laura partnered with dear wonderful Ellen Pence, and they created a curriculum for practitioners working with women who have used violence in intimate relationships. And I'll put up information on how you can get to that once we start. And she, Melissa, like Scott, has also testifies as an expert. She has lots to share about what she's learned doing this. Melissa, I just learned so much every time I get to listen to or talk with you, and so it's really my honor and privilege to get to introduce you today. Like I said, they have a lot to share. I want to turn it over to you. Just a reminder, if you're having trouble connecting, try calling iLink support at 800-799-4510. Any other questions, put them in the chat box. Thank you for your patience, and now it is really my pleasure to turn this over to Scott Miller and Melissa Skaya. Thank you so much.
Thank you, Sue. This is Melissa. Scott and I are going to be kind of doing these slides together, and so, of course, the disadvantage of a webinar is that we can't read each other's body language, and so we hope this go seamless because we are in different parts of the state of Minnesota. I'm in the central western part, and Scott's in the eastern part of northern Minnesota. And so I have to tell you that I just see that my friend Rhonda Martinson is on this webinar. And I will tell you that I'm glad that she's on it because Rhonda is the person who is responsible for me really starting to do expert witness testimony. I'll never forget the day. I think it was back in 2006 or 2007. Rhonda had given me a call. At the time, she was working with us on a safety and accountability audit, or what's now called community assessment with Praxis, to do one of those, an audit essentially with our prosecutors. And so I'd gotten to know Rhonda when she spent a lot of time here. And so at that time then, a short while after she had left our community, she gave me a call and said, I had a prosecutor, a group in Stearns County, Minnesota, who has a felony domestic violence court. They really want an expert witness. I think you should do it. And my very first thought was, oh no, defense attorneys are mean. And I really like, nice people. I like to hang around nice people. And I thought, I really like to feel good about myself, and lawyers like to rip you up and down. I don't know. Well, here you go. So Rhonda talked me into it. And so we did that first case back then. I think it was maybe 2006. And so we've been doing it since then. And so we're here just to share our experiences. I have to tell you, my biggest resistance to doing it at the time was being called an expert. An expert to me had this idea of the be-all, end-all, and sort of knew everything. And I just knew that I always wanted to be in this place of always learning about the work I'm doing and constantly thinking about the experience of women and talking with women about that experience. And so what we're going to just talk with you about today is, what we've learned from doing it, our experiences doing it, and then we have some recommendations about sort of the do's and don'ts. And then if you're thinking about doing this also, of course, what that means and how you have to prepare for that. And then also, if you don't think you're the right person, about how to talk to a prosecutor about it. And so just to give an example, though, in the state of Minnesota, as far as Scott and I know, there's only 3 of us who are really doing this on a regular basis. So I'll just say as a person who is doing this, I get way more requests than I'm just able to do because, I'm the director of a domestic violence program in 2 counties and also a mom of a 7-year-old and 8-year-old. And so we really also want to do this because we want to encourage other people to do it in other parts of the country and also, of course, in Minnesota for us so that there are other people here who will do it. And then we want to create some sort of network amongst people who are doing it to sort of learn about it. So when we sort of think about, what's the goal of this, we're thinking about that the goal of the testimony is to help explain the counterintuitive behavior. So that's sort of one of those terms that came out of one of those resources that came out from the National District Attorneys Association. Jennifer Long wrote a piece that we have a link to. You want to take a look at that. We also wanted to provide alternative explanations for victim behavior. The words used, the prosecutors used in the case, there was delayed reporting, or she recanted, or she stayed, and I need you to explain that. We also want to look at how to humanize victims of battering to the jury so they can empathize with the choices she's made, and also expose his actions and behaviors to the jury so they can understand him. So Scott, do you want to say anything else about ways of introductions to yourself or about that?
Well, yeah, I think that, one of the, so we're there to talk about the behavior and choices that she's made. But because Melissa and I both do groups with men who batter, we can talk, and we use the power and control wheel and the tactics on it to help explain that victim behavior. There's a way to bring that conversation about what he does and what the resulting impact is on her. And there's a lot of credibility when you're in the court and you say, when I ask men in group this question, this is how they tend to answer about why it is they do what they do. And then when they do this, this is what the behavior is on her part. And linking those 2 things together, because technically we're not there to talk about who he is, but in the process of our testimony about her behavior, part of the explanation is explaining what it is that he's doing that's causing this behavior. And that picture helps the jury understand the case before them, of which we don't know any of the facts. And so I think part of the power of this is that when we explain things about him or her, and they know that that's what's just been testified to, or that's part of the facts of the case, that lends a great deal of credibility to in our case, the prosecutor's case against the offender.
The other sort of personal I'll just say for myself is that, just locally doing advocacy for a really long time when I started and working on the coordinated community response, we just know that prosecutors always felt like, that they're always in this bind about when victims, they knew, they had some indication that they were going to minimize, they were going to recant, and so we wanted to just be a part of what I would call sort of the biggest struggle, one of the biggest struggles in advocacy, which is how do you balance her safety and empowering her and going with what she wants with holding offenders accountable in the community. And so Scott and I will talk more about this later, but because we don't do victim advocacy right now, I mean, I do it in a rare situation right now as a backup to someone or mentoring, but because of that, we wanted to be a part of a community where batterers and offenders of domestic violence, men who batter, that they don't walk around this community with this thinking of, I can do this with impunity, which means that I can walk around this community and never be held accountable. And so we wanted to do that, in this balanced way. So I also just want to say that we also, just from the get-go, we want to say that we've done this, Scott and I both, only for prosecutors so far. We haven't done it for defense attorneys, but it doesn't mean we wouldn't. We simply just haven't been asked. And so we just want to say that we're open to doing it for both. We want to look at, the case and all those sorts of things too. But when we have you think about being an expert in what to consider, Scott and I have a pretty hard rule right now. We didn't at first, but right now we have a commitment to not testify in our own community, that we will, the areas in which we serve. And we don't want to do that for a number of reasons, but one of which is we end up knowing a lot of the people who work in the system, which, including the defense attorneys and having relationships with them. But also we don't want to be tied to a program where if a woman knew me as the leader of this organization and she was not in support of him being prosecuted, we wouldn't want her to tie not coming to the agency because I had testified. And so we'd want to do that outside of our geographic area. And so Scott and I kind of have agreed that, I would go, for example, to Duluth. In fact, I know Mary Asmus is on from the City Attorney's Office in Duluth. I owe her a testimony. She and I have one that I'm going to do there at some point. But we just don't want to do it locally. We don't recommend it.
The other piece, too, is that we both run men's programs in our agencies. And so, a lot of what we're doing is trying to limit what I would call the liabilities for attack. And so now I'm up on the stand and I'm testifying about, as an expert witness on behalf of the prosecution, who's trying to convict this particular offender, who, if convicted, will end up in one of our men's programs. And so to eliminate any of that, any line of questions from the defense about that, we don't. That would be another example of why we don't testify in our own communities.
And then, of course, if you're going to prepare for this, you have to do curriculum vitae and update your resume. And so I'll tell you that when Rhonda called me that first time, that was the thing that took the most time. And Sue, I don't know if is that in the Google Docs, the curriculum vitae, or are you going to pull it up, or?
I can't pull it up, but it is in the Google Doc.
Okay, perfect. So you can take a look at it there. We provided you a copy of mine just as an example, but essentially every training you've went to, you've trained at in your community, you're going to have to write down. And so all those experiences, if you think about, if you've been doing this work for 10, 15, 20, 30 years, I mean, that's a lot of trainings you've either participated in as a trainer or co-trainer, as a plenary speaker, or you've done in your community, or that you've attended. And so in part, it's in paper, in writing, what your credibility is. And the same with your resume, you have to update that. And so you want to make sure that all your I's are dotted and your T's are crossed But I'll never forget one of my first times testifying. For the most part, the defense wasn't very organized around this issue, but then I got one defense attorney who actually had done their homework. And one of the things and I don't remember how I had it written before, but basically I get asked to read and review and edit and become a contributing writer to articles and publications. So there was one I had done with the Family Violence Prevention Fund, which is now Futures Without Violence. I was reviewing and a contributing writer to theirs. And so the defense attorney had actually printed it off and said, so Miss Gaia, you had put on your curriculum vitae that you were a writer in here. I want to know which words you wrote in this document, because you have left this court with this impression that you are the author of this article, right? And so that sort of stuff will come up. And so, you want to just be as clear and really looking at your own vitae or have someone else look at it from a defense sort of look at it about how you could pull it apart. I mean, they'll always take things, of course, and twist it and turn it, all those sorts of things. But you really need to make sure that the accuracy of it is just really tight.
Well, and that you have, and that anything that you list down, like if you look at Melissa's, or my Vita, there's tons of trainings on there, pages of trainings. You don't put anything down that you don't remember what it is that you did, because you can about guarantee that the defense isn't going to ask you about the last one you did. They're going to ask you about the one you did 7 years ago in Bismarck, for a half a day. What was it exactly you were doing? And if you look like you're hesitating or you look like you don't remember, all this is about credibility. And so they're going to do everything they can to impact your credibility, because that's what they have to go after you with. So again, anything you can do to minimize that, and if you got to leave something off, leave it off. Just make sure what you're putting on there, you know exactly how to talk about each one of those, either trainings or different jobs that you've had.
We also highly recommend that if you're going to be an expert witness, that you be someone who reads the research, that you keep up with the national literature about domestic violence and the reputable research about domestic violence and the theories about it, and that you also then tie that research to your firsthand experience, and so that you're not talking like a college professor, even though I love my college professor colleagues. There's a certain speak about that. You don't want to sound too academic when you're testifying, that you really just want to talk in what we would call normal speak, per se, because your audience is really the jury. And so you want to be thinking, a real simplistic way is to think, I'm going to do a presentation today, in X community, and my audience today is the jury, to think about how you would talk with them. And
now here's the balance. As Melissa said, the real credibility to the jury, and you can just see how the jury can shift when you have, make a statement about this is a very common characteristic of women who batter, and then you back it up with this story to help them understand what it actually looks like on the ground. But one of the common defenses that can come up is that, like, how do you know that the women that you've met are really victims? One of the ways in which this was asked of me at the last time I testified was, so when he calls from the jail and they come up with what you're assuming is a story that's not true, how do you know that they're not actually coming around to the actual truth? That this is what actually happened wasn't the violence, but and that's when it's good to have a backup to go to research and say, well, research backs up the kind of experiences that I've had, and here's an example of that. And then it's a way of taking that kind of defense off. It's not off the table, but it doesn't have the credibility that it might if you just were sticking with your experience. So I agree with Melissa. You absolutely start with your experience, and if that's all you need to do, then that's what I'd stay there. But in those cases where you're going to need to pull in research to back up your own experiences, know that research and make sure you're prepared to talk about it when you're up on the stand.
Also, we just highly recommend that if you're thinking about doing this, that you're a person who has a good understanding of court and how court works. You've spent a lot of time there, in part so you understand the language and what's going on in the courtroom. I really wouldn't recommend it for someone who hasn't done a lot of courtroom or legal advocacy, just in terms of knowing what's being asked of you, what's expected, and in part knowing some of the dynamics that happen. For example, if the first time you've ever seen a defense attorney be mean is when he's doing it to you, you're going to crumble. And being an expert. Or
you may get mad.
Yeah, or you get mad. And being an expert witness and being vicious or crying is not recommended. It doesn't do anyone very well. And so we really want people who have spent a lot of time in the courtroom and have really a strong link to the experience of women who are battered and men who batter in that work. But also, we also would say that we think it's best if you have a lot of training experience. So if you've done any training at all on a national or statewide, you're well positioned. It doesn't mean that if you haven't, you wouldn't qualify as a expert witness, but people who've done any sort of statewide or national training workshops of any sort are in a much better position to be qualified as an expert witness.
So part of the filter that to listen, there's a lot. You could be an advocate in a small community, and you might not have done any training. You might not have participated in any kind of national conference. But you have all that experience working with women. You can get up and you can testify. At least statute in Minnesota would allow for that. The whole thing that I think we're talking about is all the ways in which you can limit the time you spend on the stand having to explain why it is that you deserve to be there. And the more that you are able to limit that, the more credible and the more focus you have on the counterintuitive behaviors of victims and his behaviors. That's what the jury ends up hearing, rather than a long, a great deal amount of time with you trying to get qualified as an expert witness in front of the jury, if that's where it happens. One of the things that I'd suggest to do that was very helpful to me, having done enough work with the criminal justice system here in Duluth, is to go to our best defense attorney and ask them for about an hour and a half to give them all my materials and testify in front of them, and then give them free rein to beat me up as bad as they possibly could. And I learned a great deal of what I was doing on the stand that might create some of those liabilities. For example, the defense attorney in our community said the number one thing I want to do with you is turn you into an advocate. So anything that I can get you to say that says that I'm an advocate on behalf of women and I do whatever it takes to help them, if I can get that in front of the jury, then I've got you. And I'm gonna be able to really impact your credibility. So that's
right, and just want to clarify, Scott, it's not because being an advocate's a bad thing, but it creates bias, right?
Right.
And so then
the
jury won't hear you as an expert.
Right. You're not this unbiased expert who's talking about the general characteristics of battering. Now you're an advocate who does a particular job. That's why, another reason why Melissa and I don't do this work on behalf of our agencies. Again, does it knock us out? No. But it puts us on the stand, and the defense can come up and say, so who do you work for? I work for the Domestic Abuse Intervention Project. What's their mission? To work on behalf of women who have been battered. And then the next question is, are you doing that right now? Are they paying you? Are you not fulfilling your mission, right? So there's all these questions that end up coming up that you don't want to have to address. So all experts, for the most part, get paid a fee, and we basically have the prosecutors deal with the fees right up front, take the wind right out of the sails of the other attorney, and then it's out of the way. So yeah, you're always thinking about how do I reduce any liabilities that I might have on the stand as an expert.
Right. So early on, when we were getting a lot of requests, we sort of worked this out because we work for nonprofit domestic violence programs. We asked this question before, leadership and our board of directors, and so we all just agreed that the best thing to do is that, I take vacation time from my job here. I don't do it within my capacity here. I have to use my own time, and so I get paid for my own time to do it. And so I'm not representing the agency. I'm representing myself, and that's who I am when I'm there on the stand. So what happens then is then you're going to get, if you're thinking about doing this and people find out about it, then attorneys will call you. And, then it's about what do I need to know about the case. And this is the thing I'll say that we've changed our mind about, and I know that there's some debate in the field about this. And I know that your previous calls have been about the two different types of testimony. So we want to be clear that we're providing expert witness testimony about the issue of domestic violence and its effect. That we're not reading through a case file and then providing an expert opinion about any sort of dynamic or person involved in that case that's before the court. And so to that end, what we've now changed and do now is we don't want to know about the details of the case. So mostly what happens is an attorney will come say, I have this case, and they start talking, and we say, whoa, hold on, nope, don't tell us, we don't want to know that. And so, we usually don't let them get too many words out. And so we've sort of decided that these are the things that we want to know about the case. We want to know if it's a heterosexual or same-sex relationship. We want to know the gender of the offender. And we want to know the purpose and the need for the testimony. And like we had said, no case-specific facts or details. Because in
the reason
part
we want to,
go ahead.
The reason we want to know that information is because that's where a lot of the literature and the research that is out there goes to intimate partner domestic violence, where a male is an offender and a woman is a victim. And if it's not that, then we have to go to other research, and we have another way of talking about what the dynamics are. So we need to know that information to know how to talk about and answer the questions that are being presented before us.
Right, and so that, in part, what we're creating, and then when we're sort of preparing with the attorney in terms of the preparation, we're really getting to know, there's something that's going on in this case that the prosecutor believes the jury will have a hard time to understand. And so the prosecutor's job and work is to think about what sort of questions will draw that out, right? And so that, we'll talk more about that in just a minute, but at first we have to work with the prosecutor. We talk with them about and get them our information. So one of the first things we'll do is email them our curriculum vitae, our CV, and then our resume. And then we'll also, depending on what sort of hearing we're going to testify at, it might be a pretrial motion about whether an expert is qualified, about whether an expert is relevant, or it may be in the middle of the case. We've had wide and varied experiences. But we're going to spend some time talking with the prosecutor and having them think about what it is they want to highlight about our experience and what questions they're going to ask us about our testimony in terms of getting qualified. But, that's the first sort of stage of this, is doing that, and preparing with the prosecutor ahead of time will make that, go well.
And this is one of the pieces that can frustrate both Melissa and I a little bit, is that especially when we're working with a prosecutor who hasn't done this before, they'll give us a call and they'll say, well, we're going to ask for time to prepare because we want to know what the questions are you're going to ask. We want some time to develop a narrative in our head about how this testimony is going to go, what they're interested in, and you'll get an answer sometimes, well, I just need you to get on the stand and say that most victims recant. And there's a whole lot more that goes into this testimony than just Melissa or I getting up on the stand and making that statement. So how do you build up the fact that we're experts and can give a credible opinion on this, and really push them to, it's almost to the point where I will, with a new attorney, I will go through, like, for example, my Vita, and I'll say, okay, let's take the training. What are you going to ask me about there? And get their question done. And it's almost like we're the ones who are helping them design how they're going to ask the questions that qualify us, and then get to the point where what are the things you're going to ask about in the facts of the case? What kind of questions do you want to ask us that relate to the facts of the case? So here would be an example. So we want to, Scott, could you tell me about what emotional abuse looks like in a home where there's battering? And we have the power and control wheel up there, so they're asking about that tactic. And I say, well, one of the things I said in this particular case was, having read police reports for 13 years, I've yet to read one where the offender, who's male, is referring to their partner by her name in the report. She's all kinds of names. She's a cunt, she's a whore, she's a bitch, she's all those names, but it's not her given name. And what I don't know is that they've got videotape of this guy getting arrested, screaming all those names at her as he's getting pulled out to the car. So what the jury sees is me talking about who these men are, as men who batter, what they do, and then they've got the evidence that backs it up, and then the prosecutor can tie those things together. That's really where the power of our testimony goes, and that's hard to do if you don't prepare, because the prosecutor doesn't know what you know, and I don't know anything about the case. And so Melissa and I kind of think about ourselves as, we've got this cargo that we can deliver, and it's varied and it's deep, but it's the prosecutor who drives it. And we really are as effective as the prosecutors helps lead us through our testimony. If they don't do that, then things can fall apart, and they have. I've been in that moment where things didn't go as well as they could.
Right. So in part, that's what we want to think about. And I always know, like if I know if there are children, for example, that's also sometimes I want to know that. Then I'm going to spend some time reviewing the literature, thinking about what I know about this. So there's some small things I want to do, but the questions have been pretty typical. They're most often about why do women stay, why do women recant, why do women delay in their report, and what's the impact of this when you have children. There's been one time when there was about religion, about there's a victim who had said something in her statement about not believing in divorce and what that meant. And so we spend some time when we're preparing to review the literature and really just sort of prep ourselves so that, we can find it. Like Scott just had a case recently where the prosecutor, if you want to share that, where he asked you to find it in the literature you had provided.
Right. So that was when he was questioning if I really knew that these were genuine or actual victims, because I wasn't there. When I went to the research piece that I was using on jail calls, which I think is one of the docs that are up, or a link to it is, that I said all the women who were victims in that research piece were identified as actual victims of significant violence. And the defense attorney said to me, that's in this research? And I said, it is. And he didn't think it was. He clearly had skimmed it and didn't read it and didn't see it and didn't believe it. So he walked up to the stand and he gave me the research and he told me to find it. So I found it. And I read how all the women in these cases had either had severe lacerations, broken bones, unlawful detention, or kidnapping. And so, at that point, he turns a different shade of white coming up to the stand and grabs the research back and walks back and says, so you wouldn't submit that you don't know if these were actual victims? And I said, I would not. It really took the wind out of his sails, because he was hanging a lot on this notion that you just don't know if they're actual victims. So when you know your research and you can go to it, my experience with defense attorneys, for the most part, is that they don't look at it. They don't read it. They don't spend much time with it. And then this was the first time that it actually was a liability for one of the defense attorneys.
We have, in terms of slides of visual aids, we prepared it's 4 slides in a PowerPoint to be used during the testimony. Now, some of the judges have allowed it, some of them haven't. For the most part, they have. But we wanted to provide a visual for those jurors who are sort of visual learners and help sort of, provide a testimony that allows the jurors to really just sort of digest what they're hearing, but also what they're seeing. And so it's pretty minimal. It talks about what is battering, has the power and control wheel on it, and then there's one slide called the 6 F's of why about women who stay in abusive relationships. And so we didn't want to make it overly complicated. We wanted to, though, sort of take the most important things that we thought and really just sort of have those as visualizations for the jury to sort of be able to see. And so when we talked about this a little bit, but when we're being qualified, there are some times where it just gets submitted and we never ever go through a qualification. There's a time where we've gone through the full qualification phase in front of the jury. I've done it mostly in a pretrial hearing. And so we wanted then, there's also what's called a Fry hearing, which may be possible, and this ties to what we're going to say in just a few minutes, but it's about whether or not the testimony for which you are about to speak towards has some sort of scientific expert type basis for it. And so I haven't had to do any Fry hearings at all. Scott, have you?
There was requested in one hearing or one trial that I was participated in, and the judge denied it because the statute in Minnesota says if scientific, technical, or other specialized knowledge will assist the trier of fact. So what I was testifying to, or Melissa testifies to, falls under other specialized knowledge. And it's not a scientific theory, so it isn't subject to that. Well, the judge determined it wasn't subject to that hearing.
Right. You also just want to think about your demeanor as an expert witness, because in part, the way in which you present yourself from the very moment, you walk into the courthouse, you don't want to, if you're waiting in the hallway or in the bathroom, you don't want to be chatting with people. You just don't know who's a juror. And I've always been surprised when I've seen people outside and then, now they're in the jury box. And so you want to be really sort of careful about that. And then your demeanor in terms of when the defense, if they do get to a point of, not being so kind or being a little bit short in their questions or trying to confuse you, that you don't engage in that. And it can be really difficult sometimes to not want to try to defend your position, what you have to say. In the cases where we've testified for prosecutors, I've just always known that the prosecutor, if something needs to be clarified, has been listening, essentially, and that they will ask a follow-up question if they believe one is necessary. So it's really important that you don't, get into an argument with the defense attorney. You don't debate sort of in your style with them, that your demeanor really sort of be, in the regard of, this is what I'm here to do, and I'm not here to sort of fight with the defense attorney, because I'll tell you, some of them, we haven't had many bad experiences. As Scott said, most have been pretty unprepared. But the 2 that have been really tough have really just gone to task. And, it's just little snide remarks about the sort of degrees we have and about whether we had enough education or not enough education, about whether we're a clinician or not. So it's those sorts of things that they like to just put little remarks in, I would say.
Yeah, and I think that when you understand that the defense is just doing their job, that this isn't personal, and you have a job to do as an expert witness, and the prosecutor has a job to prosecute the case, and everybody's just doing their job, and this is part of a defense attorney doing their job. Anything that you can do to keep it from because if you make it personal, even slightly, even with a little snap, like they snap at you, and so you give a little snap back. That can appear to a juror as that you're not that unbiased person on the stand there to answer questions, that you have an agenda. And there's nothing more that they would like than to expose an agenda and you as an expert. So, one of the things that you can do in your communities, which I took advantage of here, is we have a law enforcement academy just not too far from the city I live in. And I asked them if I could audit one of their trainings that they put on for how to testify in court for all the law enforcement cadets. And so I sat in and I listened to a prosecutor and a defense attorney and a judge come in and talk about all the things that are really important about your demeanor as a witness in a case. And these are ways that you can, educate yourself so that, to me, I guess for me, if I know what's going to happen, if I can picture what's going to happen next, then I have a lot less anxiety about what's going. I feel much more prepared and much more relaxed. If I don't know what's going to happen, if I don't know what a FRI hearing is, then that can fluster me. And so I'm somebody who prepares a lot, and I do that because it keeps me relaxed on the stand. So you just have to find out for yourself. When you go to a trial, watch somebody testify. You're going to see people do it well. You're going to see people not do it well. And then you're going to see, you're going to learn from their experiences about what to do, what not to do. Even taking the oath. I would have not had any idea how much jurors put into the witness taking an oath. That their hand is straight, that they take it with the utmost seriousness. They take their job as jurors very, very seriously. They take their oath seriously. And if you don't take yours, they wonder why. So there's just a lot of little things that can get in the way of your testimony, again, and your credibility, which is all you really have up there. And so anything you can do to observe court, to work with the defense, work with prosecutors, go to a law enforcement academy, watch them teach the cadets how to testify, any of that stuff is just of great help.
The other thing that we just want to mention is just also towards you, Demeter. I don't want to say a whole lot about dress. I just want to just tell a quick little story, though, is I have a lucky court outfit, and every time I've testified, the juries come back guilty, and so I felt quite committed to my suit and my outfit. But just
want everybody to know that I don't have a lucky court outfit because
yes, because he has had a not guilty verdict. My record's quite clean. His isn't.
It's good to know that we're not counting, though.
Right, but we are. But I'll just say, and here's the other thing I'll just say just from learning is just about making sure that when you say yes, you really have enough time to do it, because I made the mistake of not. I had a case. I was in the middle of a big grant project at work and a whole bunch of things. I was going to have to travel 3.5 hours to get the expert witness testimony. My kid said something the night before, so I had to get up I had to be at the Minneapolis courthouse at 9, so it meant I had to leave my house at 5 because I had to account for traffic. And I literally get to Minneapolis and realize I forgot my court clothes at home. So now I'm in Target in the court clothes section looking for the clothes, right? And so all of that, I just knew that it was just, my mind wasn't there. I hadn't taken enough time to prepare. I forgot my clothes at home. And so I just really encourage you that if you're going to do this, to really take time before to prepare time, relax time so you're not sort of rushing to the courthouse, because I've done that and it's not gone so well. We would also say to make sure that you Google yourself and watch your social media self. And so the thing about that is that you want to, the good defense attorneys have Googled me. They've pulled up, everything about me, and so you want to make sure know what's out there about yourself online. So I just have to comment to this question right now because on there that does Target have the court clothes section? Well, I did my best. I happen to be at a bigger Target in Minneapolis, so I got the best Target suit you could get for court. So anyway. So this is one of the really important parts that we've sort of spent a lot of time on when we think about how we define what we testify about. And so, over the course of time, early on it was called battered women syndrome, is what the testimony was about. And so this was in part, the battered women's syndrome theory was in part tied to the cycle of violence theory, which was coined by Lenore Walker in the late 70s, early 80s. And so that theory, the cycle of violence theory, said that there was a tension-building phase, there was a violent episode, and then there was a honeymoon phase. And so it's really important that, you know, you sort of know this sort of progression of what the thinking is about the theories of domestic violence. You know, that theory of the cycle of violence has been discredited. It's also been discredited in the literature by practitioners. And so we all, and tied to that, then we don't use that we say we're going to testify about battered women's syndrome. Now, a lot of prosecutors may call you and say, well, that's what, you know, I need you to testify about battered women's syndrome. And then so we just spend some time talking about that. And so in part, we've sort of landed on saying that our testimony is going to be about domestic violence and its effects. Now, the rules of evidence in the state of Minnesota generally say that the opposing counsel is entitled to some sort of summary or information about what an expert's going to testify about. So I know in the Google Docs, there's that document is there that we wrote. And so we provide that to the opposing counsel so they have a summary of what a testimony will be about. Now, this is really wide and varied. Sometimes they don't require it at all. Sometimes they ask for it. Scott has a story about notes. Do you want to say a little bit about that, Scott?
Can you say a little bit more about?
Oh, just about even the notes when you're meeting with the prosecutor, that was required to be submitted because it was discoverable?
Oh, yeah, right. So, yeah, again, based in some of, like Minneapolis, St. Paul, when I've been asked to testify there, everything I say in our prep before the trial gets documented in notes from the prosecutor, and all that has to get supplied or given to the defense. In most jurisdictions in Minnesota, the defense isn't requesting it, so it isn't given. But again, just knowing what it is that you are at times going to have to produce, and of course that preparation was much longer than that was about 3 hours because of all the typing and the note taking that had to take place. And the clarification and all that. So it almost doubled the time of prep. And again, it's just things that you need to know about what it is you'll have to produce at times.
Right, and so I'll tell you that I had one case in the state of Minnesota that went on appeal, and it's an unpublished opinion. But in part, the defense attorney tried to trick me. Good thing I was on my game that day. But the defense attorney had said, so, Ms. Gaia, when you testified about battered women's syndrome, and I said, no, I'm sorry, sir, I did not testify about battered women's syndrome. And so in part what he was doing, which I didn't know at the time, and this is one of my very early on cases, when he was asking me that question, he was setting it up for appeal. So there, you have to really pay attention to all the questions and understand this language about the difference, about what you're actually testifying about. And the thing about battered women's syndrome and why that language isn't being used, because it was seen as some sort of diagnosis, some sort of that there was some sort of clinical assessment, and that some sort of syndrome was sort of diagnosed as a result of being a battered woman. And so we don't say that our testimony is about that.
And on the appeal, the court said that the distinction between battered women's syndrome and counterintuitive victim behavior is irrelevant to the district court's analysis under Rule 702. Battered women's syndrome may or may not be scientific, but common behaviors of victims of battering falls under the other specialized knowledge that the expert bases their knowledge from. So, at least in Minnesota, the courts have determined that battered women's syndrome is not what we have to testify to.
I also just want to say a little bit about sort of our decisions about who we testify for, why, and when. Because the other thing that will come up is that there's going to be a number of high-profile cases in your community, and so you're going to have to make a decision about whether or not you'll testify to those. There was one in Minnesota recently where a Minnesota Viking NFL football player was being charged for with domestic assault by strangulation in the state of Minnesota. That case got a lot of media attention. Scott was on the witness list. I was asked first, but my husband's related to the defense attorney, and so it was the easy out for me. But you're going to have to decide. I mean, I just know that I'm not interested in that. You know, I don't mind the semi-mean defense attorneys, but the ones, you know, in the high-profile cases, I'm not going to go looking for those. I'm going to generally just not be the person who's going to volunteer. I'm probably just going to give them Scott's number is what I'll probably do. But you're each going to have a different level of comfort about whether you're willing to do that, have that level of scrutiny. The other thing is that, of course, when you sign the subpoena, you put out your vitae and your resume. The defense gets a copy of that as well as their client. The recent case, I had prank calls at my house right up until the trial date. I knew it was some connection to the defendant. You know, I just ignored it. I wasn't going to make a big deal about it. But, you know, there is some of that stuff that may happen when you just sort of put yourself out there in the court in that way. But generally, those sort of drawbacks are pretty minimal in our experience, and so we wouldn't, you know, want you to shy away from it just because of that. But know that, you know, that there's always a risk because you're putting your address, your home, all those sorts of things are being made public for the record. So we want to add. We have some more things to say, of course, but are there any questions that people have? Are they all going to come on the public chat, Sue, or?
No, Cindy's going to talk to you.
Yeah.
Oh, okay. Great.
Okay, so Cindy will ask you the questions. And if you have, well, Cindy, you can figure out if you want them to keep talking now or ask the questions now.
I think whatever makes sense for Melissa and Scott. I have one question from the participants, but I have a bunch of questions from myself. So however you guys want to do it.
Yeah, go ahead either way.
Okay. We got a question pretty early on from Alma Borgia, and she was asking you to clarify how you talk about, you know, whether or not you're an advocate when you're testifying. Her question was to clarify so you don't identify yourself as an advocate. So can you talk a little bit more about how when you're testifying as an expert witness, you clarify kind of your advocate role from your expert role?
Yeah, so in my current position right now, I don't do much advocacy. I do some of it as a backup for staff or on vacation, but I don't do it as part of my regular day-to-day work. I used to, though, for years, and spend quite a bit of time in criminal court, and so we'll talk with women on occasion there. But really, we're really sort of separating out that we're doing a lot of that now because we believe that it creates a sense of bias in the court. And so it's one of the things that I always get asked is how many women I've assisted, and I've estimated it and said I've estimated it. And so that's important, and the credibility of having done a lot of that. Right now my work is mostly in group process. I do the group for women who've been arrested, and I also do a lot of focus groups and do a lot of CCR work in the criminal justice system. And so my work tied to the experience of battered women here and now is in that way, but I'm not doing a lot of direct advocacy, and so that's why I wouldn't talk about it. But we believe that there's a liability if you're doing if your primary job right now is advocacy, and let's say that's what you do almost all day, you know, for your week of work in that week, that can create some sort of bias as seen by the jury. And so other people may have not had that experience, but it has come up for us for sure.
Yeah, so if you go to the Google Docs, I have a sheet that I send to prosecutors about how I explain my job and all the different things that I do. And when I first started doing this, it was really short. I didn't, to me, it would be the same as if I'm doing a training. I don't spend a lot of time talking about who I am. I'm just going to give them, kind of, this is the work I do and move on. And what the defense attorney I was working with said, if that's what you do, you create a vacuum that I can walk into and create all kinds of havoc about what you do and why you do what you do. So you can take a lot of my wind out of the sails by how you describe the work that you do. So I talk about doing coordinated community response work, and one of their big questions is when they look at my particular Vita, it's going to have a lot of trainings on how to work with men who batter. So they're going to say, so where's your contact with victims? Well, my contact with victims comes from Order for Protection Court, and I'm not working on behalf of victims, but we have both Melissa's community and our community have this rule for someone to mediate orders for protection, not mediate, that's the wrong word, facilitate orders for protection when the petitioner, the woman, wants to seek an agreement as opposed to a contested hearing. So she's got her advocates with her doing the work with her, and I act as the go-between. So I listen to victims every week in court talk about what it is that they want, what it is they're willing to work with him on, and I get to talk to the offenders or the respondents in that particular setting, and listen to them talk about why they did what they did or why they didn't do what they do, that kind of thing. So any contact that you come up with for both women who are victims and men who are alleged offenders or offenders lends to your credibility. So when you say that in court, if I say that I have a contact on average between 12 and 15 women a month, then I'm called to another case 3 or 4 months down the road, and I say that it's 5 to 10, then they're going to call back. They're going to come back to me and say, well, you stated it in another hearing that you have contact at 15 to 20. What happened to all your contact, right? So know what it is. I mean, sit down and literally figure it out. What is that average contact over the course of a year of women, and what's the context of that contact? Working in the men's program as one of the people who coordinate that, I get calls from women whose partners are in the program. So that's the context in which I have victim contact. And so there's a way, and you'll see how I've laid that out to explain what you do so that they can't turn you into something that you're not. And then I'm not an advocate. I don't work individually with women on advocacy, but I work with advocates who do. And then I also do focus groups with women for the criminal justice reform work that I coordinate. So again, I'm listening to women talk about their experience of being battered by men for the most part. And so that again lends the credibility I have to having contact with women who've been battered. So yeah, the way you describe what you do either can give the defense a lot to work with or not much. And since I've been kind of talking about my job description the way that it's kind of listed out there on that page, the defense just kind of breezes by me. They don't want to go after it because I've already developed a lot of credibility with the jury by talking about what I do. They don't want me to talk about it anymore, so they just move on.
And Scott and Melissa, my next question to you was going to be why your practice around what you do and don't want to know about a particular case has changed over time. So I would like you to talk about that a little bit more, but I guess my first question would be, is that related to the fact that you do a better job at separating your role as an objective, unbiased expert witness, from that of an advocate whose job it is to believe all victims? Is that one of the reasons why you don't want to know a whole lot about the case?
Yeah, one of the things that can happen, just as a person also who reads police reports every day and then have men's group, I rarely read what a guy sent or read his probation PSI before he comes into group, because I know enough about myself that I want to stay open to his process to change and not just know all the awful things he's done, but I want to get to know him first for who he is. And in part, because I know that about myself, if I read all the heinous things he's allegedly done to her in that police report and see all the photos that go with that, I just know myself well enough to know I'm going to have an edge about myself. I don't want to glare at him. I can just see some potential for that or something. And so
Melissa,
just knowing.
A PSI is a
pre-sentence investigation
report.
Thanks.
Sorry.
Yeah, from probation to the court. And so if I read all the details of the case, one, I'm going to be subject to asking what I think about what's happened in it, and I don't want to do that. That's not the sort of testimony I want to provide. And then secondly, I just know myself well enough that I'll come off in a way that I don't want to. Because most often then, when you're preparing yourself for court, this thing that happens, like, okay, now I got to remember that this thing happened. Then you end up reading the whole thing right again, right before you walk in the courtroom, and then you see him and you see her, and you just looked at the pictures, and you're thinking about, the 2-year-old child who got thrown down by him too. And so it just helps for me not to do it. But mostly it's for the reason that I don't want to become an expert about what's happened in this particular case.
I think it also helps you, like I was thinking of one particular time I was testifying, and after talking about some common reasons why women stay in a relationship where they're being battered, she says, well, tell me about how children come up if there's children involved, tell me how that plays out. And so when I started talking about that, if I didn't know how many kids, I have no idea. But what I talked about is if there's I gave different examples. So if there's one child who's young, then these are some of the things that can come up. But if you've got a number of children, how do I pick up and move 4 or 5 children out of the house? And if one of them is a 16-year-old boy and I can't bring them to the shelter, then do I leave that? So you're helping the jury go through that decision-making process that she's going to have to make about getting the needs met of all of her kids, or being able to take them all with her, or not being with one of them and not being able to protect that child, or think that she could. And so, that when you don't know any, and at the end of all of your testimony, the prosecutor is going to always ask, have I shared any of the details of this case with you? No, you have not. The defense is going to ask that. Were you provided any details of this case? No, I was not. Yet you've virtually described the case before the jury. And that, the power of that is probably the most impactful piece that we provide as experts on the stand.
And we've actually seen body language by jurors, during the testimony, because, if something's resonated, with them.
Right.
Scott had a case in even farther north Minnesota, say about the jury pool and who they ended up to be.
Yeah, they had a jury pool, and of the entire jury pool, they only had 6 people they could find who did not grow up in a home where there was battering.
Wow.
And so half the jury came from those homes. And so when I was talking about some of the dynamics around children, there was an audible gasp by one of the jurors that you could hear in the courtroom. And when I asked the victim witness person about that after the case was done, she had followed up with that juror, and the juror had realized something about her childhood that she had never put together before through my testimony, and that's what made her gasp. And then there were 2 men, I would guess in their late 70s, who I couldn't really read and didn't know if they were with me or they weren't, or But when I started talking again about those kids, and evidently I think she had a number of children, they crossed their arms and just glared at him. 2 of them, both simultaneously, crossed their arms and turned to him and just glared at him, and you could just see that there was a tangible shift in the jury, because evidently I had come across some of the evidence that had already been presented about the case. So.
And I think that, kind of tying these 2 questions together, something that can be really powerful, for the attorney who is calling you as a witness, whether it's the prosecutor or whether it isn't, is that, at the end, after these, obvious dots have been connected, if the opposing attorney is trying to paint you as somebody who comes in the door with a whole bucket of bias, you can actually go back to the fundamental fact that you don't know either one of the parties. You don't know if either of the parties are batterers. You don't know if either of the parties are victims. And I would have to imagine that can only add to credibility at the same time that these dots are being connected.
In fact, that's been asked a couple times. Do you have any opinion of this particular case?
Right.
I don't know anything about this case.
Right.
And so you don't know if my client actually fits the description that you have presented here about men who batter. I do not.
Right.
Right. And so, but the jury gets to decide that.
Right.
Not the defense.
Right. Right. Absolutely. And do you think? Oh, I'm sorry. Were you going to say something?
Well, I was just going to say that part of the effectiveness of that testimony too. Melissa and I were talking, or Melissa was talking earlier about that we do a lot of local, national trainings. Part of the thing that I think that really helps an expert witness is having done a lot of training. And in this regard, as a trainer, you're working with what people bring to the room about whatever topic you're talking about. And as a trainer, you've developed a library of stories to help people understand what it is that the complexity of whatever notion we're trying to get our heads around. And you're using those stories, you've edited them in a way to make a point. And so I can be on the stand and the prosecutor or the defense can ask me a question, and like a trainer, I'll pull up a story or a way of explaining things. Part of the skill of a trainer is taking something complex and being able to convey it to an audience, and that audience in this case is the jury. So I'm looking at the prosecutor, for example, who's asking me a question. I begin to answer by making eye contact with that prosecutor, and then I shift over to the jury as I further explain in greater detail whatever answer to the question I was asked, but then grounding it in one of those stories that as a trainer you have a library of. It keeps your stories from being too long, and if they're too long, then people lose what the exact point of the story is. You've edited it down, and there is a limit to how long you can talk on the stand. I mean, the defense can object that is there an answer somewhere in this person's testimony, and then cut you off. So again, that skill as a trainer of being able to edit yourself and narrow down what it is that you're trying to say to something succinct is really critical in that particular venue.
Thank you. Scott and Melissa, we have another question from a participant, Whitney. She asks whether you can explain in more detail about counterintuitive victim behavior and how you explain that to the jury.
Yeah, so we don't use that language. That language actually came out of the Jennifer Long monograph. That if you're thinking about doing this, I highly recommend it. I mean, I want to give lots of kudos to everyone who participated in writing that monograph. It's just really excellent if you're thinking about doing this. But it was just it's a way to describe something about what a victim does and how they behave that may not seem like to an outside person intuitive or logical, or what someone might do. And so we don't use that language, and so we've changed the testimony to domestic violence and its effects. The word counterintuitive victim behavior, we didn't want to say that that's what it was about. We wanted to create some different language about that. And so that's what we're explaining, what would be a common sort of response by a victim given a certain situation.
And Melissa has on the Google Docs has the written version of that that is supplied to the prosecutor and then the defense about what she'll testify to. So that'll take you right through some of that of what you're asking, I believe.
Thank you. So Scott, I was talking with Scott months ago, just kind of about his experiences as an expert, particularly the things that he did in order to best prepare himself before he got on the stand for the very first time. And he described himself as an over-preparer. And after he kind of went through the laundry list of things that he did to kind of get up to speed, I had to agree with him that he was indeed an over-preparer. And Scott, you've mentioned some of those things that you've done today, such as calling up your defense attorney friend and having her put you in the hot seat for an hour and a half. Can you talk about some of the other things you did to prepare, whether it was on purpose or not, that you found the most helpful for when you went into that courtroom for the very first time?
Well, not having done any of this before, and I came into the work because Melissa said she needed help, and she was demanding that I that I start doing this testimony because she was getting so many calls, and I was reluctant too because it's not something that I know about, and who wants to line up for a firing squad, which is what it felt like to me at the time. So I went and talked with, one was a prosecutor in Duluth who had used expert witnesses for the county attorney's office, not in domestic violence cases, but in child sex abuse cases, and said, what's your goal? What do you want to have? What do you expect of an expert witness? And they were testifying to a little bit different kinds of things than I would have been testifying to, but it gave me a general idea. Can I picture myself doing this? And then I called Rhonda Martinson, who's on the call here, and who's been just a fantastic resource for me for research. Nobody's library about articles is is bigger than Rhonda's. So, and really wanting to understand not only what it is that I'm walking into, but what is it I'm going to need to know. Because I just got this thing personally. Like, I don't ever want to get in a situation where I'm unprepared. I want to make sure that I know what I need to know to do the best job that I can. And so I ended up talking to defense attorneys, prosecutors, people on the national level. Then I started going to court, and I started watching criminal procedures. And then after that, the court hearing was done, I'd ask the prosecutor, why did that happen? And when you ask that, what was that about? And when the defense cross-examined your witness and you didn't object that time, I thought you should have. Why didn't you? And really get an understanding about strategy, so that, again, I wasn't going to get flustered when I was up on the stand. And then as I started preparing for these cases, thinking about what are the stories that I'm going to fit into the questions that I'm being asked about. I know that the reason they're asking me about emotional abuse is because there's some evidence out there about emotional abuse. So I'm telling the prosecutor, this is what my answer would be. Is that what you're looking for? Well, let me ask you about this. And they'd refine their question, and then I'd answer, and they'd say, okay, that's good. Okay, well, then I'm going to write that down. And remember, that's the version of an answer that I could answer 50 different ways. That's the version that they're looking for. And then review that before I go in and start and literally spend time in my house talking through so that the language just comes to me. So I'm not fumbling for the words and trying to figure out what it is that I want to say. And then, when I get up on the stand, it made all the difference. So that's just how I would go about preparing, because, again, I don't want to be surprised by anything. When the defense attorney asked for a Fry hearing, that I wasn't going to testify to battered women's syndrome, and my theory was novel, immediately in my head, I know what he's doing, and I start formulating my explanation as to why the power and control wheel is not a novel theory. So I start thinking about how long has it been around, how many different communities around the world have used it, how many times it's been published in different textbooks, and so that I have a solid explanation. But if I would have known what he was asking, then I would have had to sit there and formulate my answer on the spot, and that's just not a position I want to put myself in. So there's as Melissa said, there's an amazing amount of stuff from the point that you're asked to do this to walking out of that courthouse that goes into making that a successful testimony. And I just wouldn't take any one of those steps lightly.
Thank you. Melissa, did you want to add anything?
Yeah, my preference is to spend a lot of time after the victim has testified. And so it's worked out well in most cases where the victim will be the last person to testify on day one, and then I'm the first person to testify on day two. Now, that hasn't always worked out that way, but in most cases it has. So then I'm spending a lot of time the night before my testimony, because then the prosecutor has a more refined question that they know they want to ask. And so that's just sort of the way I like to work, in that way. For me, though, I do like to review the literature because I want to know where all those things are in there, because I have been asked them, myself as well. The other thing I just want to say, which we haven't mentioned yet, I want to make sure we mention, is that we have had a number of prosecutors in the state of Minnesota who have used our curriculum vitae and resume as part of their negotiations in cases. So I just want to say that our CV and resume, and we had many more subpoenas than we actually testify. Now, we don't have any quantitative data about this, but qualitative in that prosecutors, in fact, I just had one 2 weeks ago where I was going to testify in a domestic assault by strangulation case in Minnesota somewhere, and then after the defense attorney talked to his client and then called the prosecutor, he just said, he's going to take it. He's going to plead straight out. So he pled straight out to a domestic assault by strangulation. And it's not just because of the testimony, but it's the combination that the prosecutors are anecdotally saying to us it's changing the discussion in plea negotiations. So I just want to say that there's anecdotally and qualitatively, we've gotten a lot of feedback about that.
And if there's anything that we can do to keep women from having to testify in front of him, then what better outcome is there, right? I mean that he pleads. I mean, it's the straight up pleas that are surprising to me that they're getting, and the prosecutor said that just really gives them an amount of leverage when they look through our materials. They know what we're going to testify to. They can see their client all over it, the materials, and it gives them a bit of leverage that they didn't have before, and to have a straight up plea to strangulation or whatever it is that they're up for. And we're mostly testifying in felony cases. I've testified in 2 misdemeanor cases, but all the other ones have been felonies, and to get a plea up to a felony charge is without having to go to trial is success.
Thank you. I think it looks like it's about that time, Sue O.
Wow, thank you guys so much, Melissa and Scott. That was really informative and really helpful, and I feel like we could do another one, so maybe we'll talk to you about doing that. It was just really helpful. So in the interest of time, I do want us to finish now to really honor everybody's very busy schedule. Just before we sign off, do either you, Melissa or Scott, have any final words right now?
No, I just say we encourage people that they can email us if they have some questions or some concerns or, about doing it for the first time, for sure.
Yep.
Scott?
Thank you for considering doing this in your community.
That was terrific. So thanks to everybody, and thanks for dealing with, we had a couple glitches here with the chat, but I think we did just fine. So hopefully the next time we have a webinar, all the technical glitches are fixed, and it will just go super smoothly, which I think it did from probably your end. So thank you, everybody. I'm going to hang up now. Unless you want to say really nice things to Melissa and Scott, you can write that in the chat box now, so I'll give you a minute or two to do that because I think they really did a great job, and I'm sure they'd appreciate hearing from you. Remember, you're going to get an email from me It's going to have a short little survey in it, and it's a SurveyMonkey thing, and it asks 4 quick questions, and you can put comments in there if you want. It's just incredibly helpful to us. It's helpful to the presenters. In that, we also have information about our website, so you'll have that link again, and we'll put the link to the Google Docs is also on that, so you should get all that information again. Okay? So thank you all. Talk to you soon, I hope. I hope you'll join us for the next one, which is on June 20th. Have a good evening. Bye.